Professor Hepple, this is our second interview. The first was in August last year when we covered the period in your life between your early years as a boy in Johannesburg through your training at Wits and to the point at which you left South Africa in 1963. Perhaps today we can deal with your life post-1963 when you were based in the UK, and can I ask you to cast your mind back to the end of that year when you first arrived here?
Yes, well, I arrived in England on a cold December day seeking asylum, and I said to the immigration officer that I intended to study at university, and he asked me, where are your letters of acceptance? And of course I didn't have any, so he immediately served me with a deportation order to go back to Tanzania, where I'd already been granted asylum. But my friends outside contacted Canon John Collins, who was a great friend of those involved in the anti-apartheid struggle, and he, I was told, then phoned on a Sunday morning the Home Secretary, who was then Henry Brooke, and I was let in for 7 days, and then I was let in indefinitely, and after 3 years, because I was granted British citizenship on the basis of patriarchy, that was my grandfather had been born in England. So that was how I came into the country. And I then had a wife and 2 small children to support, and I had thought about trying to practice at the bar in England, but I had no contacts, and I would then have to do all the training as well. And I thought I would go back to an academic career. And initially, I realized I needed to get a degree in English law. And I was thinking of going to London University. But a South African friend put me in touch with Ken Polak, who was a former South African, a fellow of King's, and lecturer in Roman Dutch law in the university. And he invited me, I met him and his wife Rosemary Polak, who was a Cambridge solicitor. And I can remember meeting in their small flat in King's Parade. And there I met for the first time Colin Turpin, another South African who was a fellow of Clare. And I also met, again, my old friend, Charles Feinstein, who I'd known at Wits, who was a fellow at Clare as well, in economics. And between them, they encouraged me to come to Cambridge to study, and they put in a good word for me with the then master, Sir Eric Ashby, and the senior tutor, Dr. Northam, and I was admitted to read what was then called the LLB, is now called the LLM.
Right, and this took you 2 years rather than the normal 3 years because you had already qualified?
No, it was a 2-year degree because I came as an affiliated student, and I had the choice of either doing the tripos in 2 years or doing the postgraduate LLB, and I opted for the LLB. I didn't feel like going through the tripos regime, and at that time you had to spend 2 years in Cambridge. Now it's only 1, but the first year I took 4 subjects. The second year I had to write a dissertation, and so I got the LLB over 2 years.
I see. And this dissertation, was this supervised by O'Higgins?
That's right, it was, yeah. When I finished the first year, I was looking for a subject, and I had been struck, perhaps I can talk about this in a later interview, but I can explain then how I came to the subject. But O'Higgins was a wonderful supervisor, so I got to know him then. The subjects I took in the first year also introduced me to some wonderful teaching. First of all, I did conflict of laws and had Professor Lipstein, who's one of the best teachers I ever had. Then I took a subject called negligence in English and Roman law with Mr. Mickey Dias, and he too was a very systematic, very clear teacher, and it was a wonderful bridge for me between South African law, Roman Dutch, and English law, because we were comparing what I was familiar with, the lex aquilia, with the English concepts of duty of care and so on. I learnt really my foundation in English law taught through Mickey Dias. And for a long time I was very influenced by his approach, but later I changed my mind. And then the third subject I took was administrative law, and there I had some wonderful teachers as well. Professor Tony Bradley, he wasn't a professor then, he was fellow of Trinity Hall. Geoffrey Wilson, later who founded the law school at Warwick later, who was a fellow of Queen's, and also Paul O'Higgins, who did some of the administrative law teaching. So that took me into that field as well. And I did company law, and there I had Ken Polak and Len Seeley were my two teachers. And I had studied company law in South Africa, but this was a much broader course, which had originally been devised by Bill Wedderburn, later Lord Wedderburn. And Wedderburn had just left Cambridge. He had been a fellow of Clare. And he used to send me every week his handouts from the LSE, which gave me a lot of ammunition to fire difficult questions at Ken Polak and Seeley. And so it was a very stimulating year.
A very busy year.
Yes.
Because you were also called to the bar in that year.
Yeah, I was over the vacations. I did the bar course, which was different from what it is now. I had to. I was given exemption from most of the first part, but I had to do the second part, and I took the exams. And it was quite frustrating because, for example, you had to do company law, and in those days they didn't let you take into the bar exam a copy of the statute. And I can remember writing essays. There was a firm called Gibson and Weldon who used to do this, a correspondence course. And I would write these essays, and it would come back with a very poor mark saying, "Don't quote all these cases, just memorize the sections of the statute." I was telling them too much, and I had to sort of refine my technique, having done a university course, for the kind of very low-level bar course that we had in those days. So I did those exams, and then I was called by Gray's Inn in 1966. Yeah.
In that same year, you went to Nottingham University,
Yes.
where you stayed for 2 years. Were you a lecturer there?
Yes. What had happened was that when I got a first class in my LLB exam, and one of the examiners, I think in the negligence course, was Alan Pritchard, the brother actually of Michael Pritchard of Keyes College, who was a professor, I don't think he was a professor then, but he was a lecturer at Nottingham University, extraordinarily nice and warm, generous man. And he was on the lookout for lecturers, and he asked Kurt Lipstein, was there anybody who was interested, and Kurt, unknown to me, suggested my name, and I was then invited for an interview, and they offered me the job and held it open for a year while I finished my second year dissertation. So then I moved to Nottingham, and there I came very much under the influence of Professor Sir John Smith, who was one of the originators in this country of case method teaching. He had this wonderful case book on contract. It's a well-known American style, and I was slightly familiar with it from my earlier days in South Africa, where Professor Harlow, my head of department, had used it. But he encouraged me to use it in the law of tort. I was primarily responsible for teaching tort. And I found this the best way of teaching. I really enjoyed it, and I developed my own set of cases and materials, which eventually led to the publication of my case book. And one of my students there was, my first year, there was Martin Matthews, who then, when I came back to Cambridge, came to do a graduate course, and we edited this book together. So that was, I think, a big influence, John Smith and Alan Pritchard.
A very productive time.
Yes.
Early in your
Yes.
career in the UK.
Yes.
You became an assistant lecturer at Cambridge in 1968, and you stayed in this position for the next 8 years. What were the circumstances of your return to Cambridge?
Yeah. Well, I liked the Nottingham Law School, but my then wife just didn't settle very well in Nottingham, and she was very keen to come back to Cambridge. We'd had 2 very happy years living in college accommodation in Cambridge, and so I applied to Cambridge, and I was appointed first to an assistant lectureship, and after 3 years upgraded to a lectureship in Cambridge. And I at the same time was invited to become a fellow of Clare College. So that was for that 8-year period. Those were probably my most productive years.
Do you have reminiscences of any of the people who were in place when you came back to Cambridge?
Yes. Well, I mean, let me say that in my career, I've had a number of very important academic influences. One always is learning from one's colleagues. And it would be invidious to single out too many individuals. But I think the people who influenced me most were, first of all, Paul O'Higgins, because he had supervised my research, arranged its publication in the form of a book called Race, Jobs and the Law in Britain, 1968, second edition, 1970. But he immediately invited me to share the labour law lectures with him, and we developed a remarkable partnership over that period, because first of all we got a lot of research students. That was a time when labour law was very prominent on the public agenda. There'd been a report by the Royal Commission under Lord Donovan. The Conservative government introduced its Industrial Relations Act in 1971 to try and restrain the unions. There'd been the miners' strike of 1984, and the Heath government fell, and a lot of new law was coming out, the law of unfair dismissal, all these things we didn't have before. And Paul and I got the opportunities then to write quite extensively. We wrote, first of all, a book on individual employment law and various other things which I can talk about on another occasion. But we did that, and the other big thing we did was we got together a group of research students. Research students, it was easier for those from the UK to get research awards in the 1960s and 70s. And we had at one point as many as 16 people doing research in labour law in the early 70s. And many of them have gone on to important careers, such as Patrick Elias, who's now the president of the Employment Appeal Tribunal, Brian Napier, who became a professor. He was a lecturer here and then a professor, and he now practices at the Scottish Bar. A whole range of other people who went on to become either academic or practicing lawyers in this field. And we used to hold regular weekly seminars just on labour law. And we also attracted in that period some visiting professors. So two of the Arthur Goodhart professors were labour lawyers. One was Sir Otto Kahn-Freund, about whom I'll say something in a moment. The other one was Professor Volker Schmidt from Stockholm. And we also got Archibald Cox, who was the Pitt Professor of American History, but in fact was a well-known leading American labour lawyer, as well as having been the man who was sacked by Richard Nixon when he was investigating the Watergate or other scandals. So it was a very fruitful and enjoyable period for labour law. But I was also, labour law wasn't even regarded as my main subject by the faculty. My main subjects were contract tort and also administrative law in the LLB. And the LLB at that time had a rather small class, about 50 people. And I shared the administrative law with my friend David Williams, who later became Vice-Chancellor. And then Professor Stanley de Smith, who's really one of the founders now of modern administrative law, was appointed to the Downing chair. And I was asked to sort of move aside so he could take over, which I was very glad to do because he was such a distinguished and very nice man. And I worked with him in other capacities, but that meant I gave up administrative law, which I always thought was one of the biggest mistakes of my career, because it was just the most exciting moment for administrative law. The case of Ridge and Baldwin had been decided in 1964, and there were huge developments in judicial review. And I always felt that's what I should have been doing as well as labour law. But I kind of missed the boat because I got into other things. So I was tort and contract, labour law, and some administrative law was what I was teaching, both in supervisions and in lectures.
Very interesting. Well, your work was very significant during that period because your next appointment was to a chair. And that was at the University of Kent.
Yes. Well, the University of Kent, I was invited by Professor Claire Pally, who is also a former South African, and Professor Brian Simpson, to come to Kent. And they created a chair for me, and I think I succumbed to flattery. And it turned out, I'm afraid, to be a mistake, because when I got there, I thought it was a university based on a collegiate system, like Cambridge, but it couldn't work in a new modern university because the individual colleges, there were 4 colleges, had no resources of their own, and everything was planned by central bureaucracy. So one moment you would be teaching in King's College, and the next moment in Eliot College on the other side of the campus. And the students law students were divided between the 4 colleges. There was no faculty building. You didn't ever meet your other law colleagues who were in other colleges. Rather like an unreformed Oxford, but Cambridge never suffered from that. And so we, after a year there, I was approached to become a full-time chairman of industrial tribunals. I had been a part-time chairman in Cambridge since 1974, and I just kind of needed a way out of Kent, but I wanted to stay living in Canterbury because my children were at school there, and my parents had moved to Canterbury as well. So I didn't want to disrupt that, and this job in Ashford in Kent came up. So I spent 5 years in Ashford as a chairman of industrial tribunals, but I remained an honorary professor at Kent, and I used to lecture on the course on, I think it was called Labour Law and Industrial Relations at Kent. I used to go up, once a week and give my lectures. So I kept a connection with the academic world, and I also wrote what was probably regarded as one of my more important books, because I had a lot of free time as a chairman of industrial tribunals. It was a much easier but better paid job than being a professor.
Well, this period must have coincided with that time of considerable unrest leading up to the 84-85 miners' strike.
That happened afterwards. While there was a period of unrest. It had been going on since really the 1960s, right down till you might say the early 1980s, the miners' strike of 84. So it was going through the period. But as a chairman of industrial tribunals, I wasn't much concerned with that, because industrial tribunals deal with individual disputes. So I was dealing with unfair dismissal, race and sex discrimination. For example, when I was sitting in Cambridge, I heard the very first case of indirect sex discrimination here in Cambridge, and the first decision on the subject reported was given by me in Cambridge. And similarly, when I was sitting in Kent, I developed, because of my academic knowledge, the notion of the duty of mutual cooperation, which was very little used in labour law until then, but I gave a judgment which was reported, and it's now regarded as one of the basic tenets of labour law. But I was able, through my judicial work, to actually develop some ideas, because you're always getting rich new material in cases.
So it must have been very fulfilling work.
Well, it was actually, in one respect, fulfilling, because you were dealing with real people in the real world. But it became very boring, because I think most judicial work is about facts, and every case is different. There's not a lot of law in it. So, as somebody who's always been intellectually fascinated by law, and had been a professor of law, I think I was frustrated, and I stayed for 5 years, and then thought, well, now's the time to get back. And I was about to go back to the University of Kent, who'd said they could find a position for me. And the famous letter came around from the University Grants Commission in 1981 or 82, making drastic cuts in funding, and Kent could not then fund the post. And that's when I applied for the job at University College London.
And this was a chair
Yeah.
which you held from 1982 to 1993, and you were the Professor of English Law.
Yes.
Do you have any specific memories of
Yeah.
this time?
Well, I mean, the interesting thing, you might ask, why am I Professor? Did I become Professor of English Law? University College London was the first university in the United Kingdom to have regular teaching English law. Blackstone had started lectures on English law at Oxford, but all of this soon died out. And Cambridge, although it had the Downing Professor of the Laws of England, was not teaching English law until late in the 19th century. But in 1828, University College London was founded for the dissenters, for the non-Anglicans, the Catholics, the Jews, the agnostics, and all the rest. And the first thing they did was establish a faculty of law. And they had two chairs. The one was the chair of jurisprudence, who was held by Austin, who was the famous disciple of Bentham. And the other was held by Andrew Amos, who was actually a practitioner and judge, who was the Professor of English law. And I was appointed to the Amos chair. And I remember Sir James Lighthill, who was then Provost of University College, saying he had Amos in me, and he had in Professor William Twining, who was appointed at the same time, Austin. He wanted to re-establish that kind of connection, because I came from the practical side of law, whereas William Twining was a great theorist. So, I think in many ways I had some of my very best teaching years at UCL. I had a thoroughly enjoyable time. I think it's a wonderful institution and a wonderful faculty, of which I became Dean and Head of Department in 1989, I think it was. Yes, 89.
Did you move down there, Professor Hepple, to
Yeah.
London?
Yes, I mean, I'd been living in Canterbury and then lived in London until 1993. Yes.
So during this time, what were your impressions of government legislation in the early 80s that
Yes.
so drastically reduced
Right.
the power of the unions?
Well, I found myself quite often on television commenting on things like the miners' strike and so on, not on the merits but more on the legal position, because this was a huge confrontation. Mrs. Thatcher wanted to restrain the power of the unions, and she basically took away the right to strike, limited it very severely, restricted collective bargaining, and generally that coincided with an economic period in which Britain was moving from manufacturing, where the unions had their greatest strength, to service industries, and also the feminization of the workforce was taking place. So there were huge structural changes as well as legislation, and one saw the role of the unions changing dramatically. And at the same time, what was happening was what some people call the juridification of law. That is, all sorts of disputes like dismissals, discipline, discrimination, which would have been dealt with informally, now became the subject of legal regulation. So it was a period of major change. But the irony was that I wasn't actually teaching much labour law, because there was already a professor of labour law at UCL called Professor Roger Rideout. And although I did a bit of teaching on that course, I think I did some discrimination law, and I started my own seminars on discrimination. I wasn't in the mainstream of labour law at that time. I was rather teaching, my main course was contract and tort. And there came the influence of Glanville Williams, which had existed before, because when I was at Cambridge as a lecturer, one day in the early 1970s, Glanville Williams knocked on my door and he said, "I've got these boxes of papers on the law of tort. I'd like you to look at them. I started writing a book. I'm now concentrating on criminal law, and I would like you to look at this and see if you're willing to complete this." perhaps I can talk more about that later, but Glanville-Williams's conception was of, if you like, a unified law of obligations, not a narrow division between contract of tort and restitution. And that influenced my approach. So when I came to UCL and had complete freedom, unlike Cambridge where you don't have freedom because you've got so many other people teaching in a topic you have to get their agreement, I could devise my own course, and I devised a course on the law of obligations. So we taught in an integrated way over 2 to 3 years the law of obligations, and we mixed it up between contract, tort and restitution all in the same cycle of 3 years for all students. So that was a very interesting experience, and there were some young colleagues who worked very hard to achieve that. So that was what the main work I was doing. It had to be reduced when I took on the role of head of department.
But nevertheless, you still maintained your interest in industrial relations throughout this time.
Oh yes. And I remained a part-time chairman of industrial tribunals. I used to sit in London North tribunals about once a week over that period as well.
So, Professor Hepple, what actually are your views on this new, if you like, sort of the relationship between the government and the unions? I mean,
that's a big topic. I don't know if I can give a simple answer. I think my views have changed. I'm certainly not a supporter of the neoliberal ideology of Mrs. Thatcher, which seemed to think, I think she famously said, there is no such thing as society, there are only individuals. And I don't accept that. I think there is society. And I think what we've moved towards is a notion of human rights to protect the individual, but you've still got to recognise the collective interest of society. An important part of a collective interest are the groups of, if you like, autonomous organisations. Universities are one, which have lost so much of their power and autonomy. Another would be the Inns of Court. And a third is the trade unions, where it seemed to me they needed some reform, but unions are a basic expression of democratic will, because they involve ordinary people in deciding on their working conditions and their lives. And I thought, I therefore was opposed to a lot of her legislation, although I fully recognise that the unions too were, in a sense, abusing their power at one point. They were, going in for all these strikes, for example, in the famous Winter of Discontent in 1979, 1980, which seemed to me an abuse of their position, and so in a way they were asking for it.
Did you ever meet any of these personalities, union?
Yes, no, I knew quite a number of the leading union figures like Jack Jones and others, and I did a lot of work for the TUC, and I was involved in advising the TUC on its proposals for legislative reform. I also advised somebody called Tony Blair, who was the employment spokesman for the Labour Party at that time. I was on a group of academics who were giving advice, but he didn't always follow advice. So no, I was involved in that, but in a way in the background.
EU legislation has had quite an effect on this area of the law.
Yes.
In your view, for the better?
From a British point of view, for the better, but I think my first contact with it came in the 1970s when I was still in Cambridge, and I was appointed to one of the committees of experts, at that time dealing with the directive on the transfers of undertakings, and then I was on several other EC committees. And I began to realise that the mistake the EC was making was to make very specific directives on particular matters where you couldn't really harmonise even partially the laws of the member states. And I started advocating in I think it was the early 80s, that a different approach should be taken. and that was to have a broad framework directive, particularly enshrining fundamental rights, and that the member states should then have greater freedom as to how to achieve the objectives. And that, I'm glad to say, is what has happened in the EU. And it was inevitable. Once they enlarged the EU to 27 members, you couldn't regulate directly all of the countries in that way. So we've had more like the famous Directive on Health and Safety at Work, which is a framework directive, and then a lot of guidance as to how to implement it. And this has happened in other areas as well. So I think labour legislation in the EU is necessary, but the current approach of rather seeking to achieve objectives on prescribing detailed regulation is a much better approach.
During this time, Professor Hepple, you were Commissioner for Racial Equality from 1986 to 1990. Can you tell me something about this role?
Yes, of course I had been active from the time I came to the United Kingdom in the campaigns against discrimination, and I'd written on the subject, and I'd had various academic commissions in that field. And then I was asked in 1986 to become a member of the Commission for Racial Equality, and that was an extremely interesting but also rather frustrating experience. And while there I chaired various inquiries, for example, the inquiry into the St Mary's Medical School for racial discrimination in their admissions, and also inquiries into London Underground and so on. I was chairman of their complaints committee and chairman of their employment committee. So it was a very interesting 4 years. Frustrated because during that period the Salman Rushdie affair occurred, where the fatwa was issued. And I think the Commission wasted a lot of time debating this, because some of us who were advocates of free speech were very disappointed at the way in which some people were protesting about Rushdie's free speech. But on the other hand, that wasn't the job of the Commission, I thought, and it rather frustrated some of the work we did.
Interesting. In 1990, the banning order was overturned that you'd been under on your days in South Africa, and you went back to South Africa. You were immediately invited to the Labour Congress in Durban,
Yes.
and you acquainted yourself with a new sort of generation of
Yes.
Labour lawyers, Theodore
Right.
Thompson and
That's
Malcolm
right.
Brassey.
Yes.
Do you have any recollections of that trip back to South Africa in
I do.
1990?
It was a very emotional experience. I can't remember if we talked about this previously, but when I came back, I was immediately met by my old friend John Dugard, who had been a student here with me when I did the LLB, and he took me straight back through Johannesburg, which I hadn't seen for 27 years, and which had been changed, a lot of new roads and buildings and so on. But I went and visited the house in which I was born and another one in which I lived, and went to the university. And then I flew down to Durban and gave a lecture to the Labour Law Conference. So it was a very emotional experience for me going back. I was actually en route to Namibia. The International Labour Organization had appointed me as an expert to draft a new labour law for Namibia, which I did. I spent some time in Namibia. And then just after that, I was invited by the new South African government I think it must have been about 94, to join a ministerial task force to draft the Labour Relations Act in South Africa. And that involved extensive meetings both in Geneva at the ILO and in South Africa. And I worked with some of the people you mentioned in that, and also I worked with my very close friend Manfred Weiss, Professor of Law at Frankfurt University. He was one of the other experts on the committee, and it was a very stimulating experience, because I felt all the years I'd spent in the UK trying to gather knowledge and understanding of labour law, I could pay back because I could bring that experience to bear when they were devising new laws. And I'd like to say that some of the provisions in the Labour Relations Act, I'm not sure how successful, were based directly on my own knowledge and experience of labour relations.
In 1993, you became Master of Clare.
Yes.
And you stayed in that position for 10 years,
yes.
2003. And in 1994, you became a member of the Lord Chancellor's Advisory
yes.
Committee on Legal Education and Conduct.
Yes. Well, yet another South African enters the picture, Lord Johan Steyn, who was chairman at that time, and I had a phone call from him, would I join the committee? Now, I had been, while I was in London, the chairman of the heads of university law schools, and I had been attending meetings convened by the Advisory Committee on Legal Education Conduct, ACLEC, and I had worked quite closely with Professor Peter Burks, who was the Secretary of the Society of Public Teachers of Law, on this field, so it wasn't altogether a surprise. Peter Burks himself disliked the committee so much that he didn't want to remain a member, so in a way I was his replacement. And that was an extremely interesting experience, but again there were frustrations. The positive side was that I was asked by Lord Steyn to draft the report of the Committee on Legal Education, its first report, which is a very substantial document, and I put a lot of work into it, a lot of discussions by the committee, and I gave my inaugural lecture as a professor at Cambridge on that report called The Renewal of the Liberal Law Degree. I won't go into detail on it now, but I think the report was in many ways quite an important turning point in legal education in this country. And the frustrating part of the work on that committee was our main task was to deal with the rights of audience of the Crown Prosecution Service in the High Court. And the committee was completely divided on this issue. And my South African experience taught me, as it taught Lord Steyn, that it's a bad idea for the prosecution to be too closely tied into the High Court proceeding. In other words, I think the traditional English system of drawing as your prosecutors people who are also people acting for defendants is admirable, because it means you can see it from both points of view and you form a more objective view. And I didn't like the idea of a professional Crown Prosecution Service at the highest level, drawn only from people who had experience as prosecutors and had never defended anybody. So for that reason I was opposed to extending the rights of audience in the highest courts. And so there was a divided report on this. Eventually the government disregarded the report completely and did its own thing, and now they've all got rights of audience and the whole situation has been transformed. But they were very stimulating years, but eventually the ACLEC didn't fit the government's agenda, and it was wound up, and a much more limited body called the Legal Services Consultative Panel was set up, and I became a member of that. But after 2 years I gave that up.
Also during this time, from 1998 to 2000, you were on the Runnymede Commission for the Future of Multi-Ethnic Britain.
That was set up by the Runnymede Trust, which is a charitable body, to try and look at the problems that had developed in Britain through immigration and settled ethnic minorities. It was chaired by Bhikkhu Parekh, Lord Parekh, with whom I'd worked on the Commission for Racial Equality. And it produced a report which I made, I have to say, a fairly limited contribution. My contribution were the chapters relating to the law on discrimination and the setting up of a single commission this coincided with research I had been doing at the time in Cambridge with my wife Mary Cousy on a review of UK anti-discrimination legislation for which we worked in this faculty, the law faculty in Cambridge.
While you were the Master of Clare, you became a professor in the Faculty of Law at Cambridge. This
Yes.
was in 1995. Did you find, Professor Hepple, that the faculty had altered greatly in the almost
Yes.
20 years that you've been away?
Well, first of all, it increased largely in size. It was a much bigger faculty than one I'd known. Secondly, it had been transformed in terms of the administration. I had been secretary of the Faculty Board of Law from 1970 to 72, and we were all in the old schools. And there was also a secretary of the Board of Graduate Studies, who at my time was Gareth Jones, and the two of us sort of basically ran the faculty with the chairman at that time, was Dick Goodison, was the chairman of the faculty. But when I came back, this was highly efficient, professional administrators and a much larger administrative staff. The other change was the library, because I had, as a student and in my earlier period in Cambridge, of course, always worked in the Squire Law Library in its wonderful setting. When I came back, this current building was under construction. I think it was opened about 1995.
Yes.
Yes. And so there was that transition into the new building. And I'm a great fan of the new building because I think it's got the space and the light and the facilities we need. I was rather sorry they didn't build rooms for faculty members as well, but I understand, first of all, the pressures of money, but secondly, the feeling that we shouldn't take people away from their college activities, and if they had a faculty office, they would never be in the college. So there were major transformations. There were quite a few colleagues who hadn't been here before, but there were also some others who I knew extremely well, like John Collier and David Williams. And I just say at this point a word about David Williams, because when I first joined the faculty, David Williams was my more or less next door neighbour. He lived over the road with his young family and my young family. So we got to know each other very well, and then we shared the administrative law course. When I came back, David had already become president of Wolfson College, and he's always been extraordinarily kind to me. And I particularly thought very highly of his works, which I don't think have been highly enough recognised in the world. He wrote a book on Not in the Public Interest about official secrets. He wrote a book called Keeping the Peace about public order, which are really seminal works, but are a style that I approve of, that they're addressed to the general public, or the intelligent public, not just to the legal profession. So I admired his work. And then, of course, he became Vice Chancellor of the university, and it was he who admitted me on behalf of the Chancellor as Master of Clare College. So it was a nice rounding up of our relationship.
Do you have any recollection of the translocation from the old premises to the new site?
Yes. Well, I mean, first of all, it caused me some disruption, because I used to be able to just slip out of the Master's Lodge at Clare through the back door into the old Squire Library, and it was very convenient. I could go there at weekends. Now I had to walk for 5 or 10 minutes to come to the new building, but I wasn't personally very much involved in the move, but it went, I thought, very smoothly. The only difficulty was about the soundproofing of the library, where we had extensive meetings, as others can tell you, and eventually we got in the screens, which I think have made it into a very attractive library and a nice place to work. I had a sabbatical year, 1999 to 2000, and I worked in the faculty most of the time on the research project funded by Nuffield and the Rowntree Trust on the enforcement of UK anti-discrimination legislation, and I found it a very good working environment.
Very pleased to hear that. Professor Hepple, do you remember Professor Dugard from this period, because he was in Cambridge.
Yes, well, he was an old friend from back from 1964, my student days, and we'd always kept in touch. He went back to South Africa and played a very important role in the resistance, if you like, to apartheid laws, and he became the leading South African international lawyer. So it was very nice to welcome him back when he was a good art professor, and he stayed for a second year as the acting director of the Lauterpacht Research Centre.
During this time, presumably, your major interest was labour law.
Well, no. When I first came back, I was asked to teach tort, and I did tort for about 2 years. But then, as I was a non-university teaching officer, and I was standing in for people on leave, I wasn't asked to continue with that. And then I got involved, well, from the start, I suppose, I was involved in labour law. So, together with Simon Deacon and Catherine Barnard, two wonderful colleagues, we really ran labour law together for the whole period I was there. And after I retired in 2001, I carried on doing some labour law teaching for the faculty for a year or two.
Professor Hepple, your retirement seems to have been extremely busy. I don't know whether you originally planned a more peaceful retirement, but then just became overwhelmed by offers from various bodies.
Yes.
But you seem not to have really...
Well, it was in 2 stages. First of all, I retired as a professor of law at the age of 67, and then I stayed on as Master of Clare College for a further 2 years till I was 69. So I gradually got out of the faculty side, although I was still doing bits of work for the faculty, various inquiries and so on, such as the inquiry into whether we should have a course of professional legal education here. And then in 2003, I really wanted very much to finish a book I'd been working on for 10 years. So the first year of so-called retirement was worked full-time on getting this book out on labour laws and global trade, which I did. And then, as you say, other things came up. I've been particularly involved in 4 human rights and educational charities. The first was something which had a long connection called the Canon Collins Education Trust for South Africa, which raises money for projects and students at university in South Africa or to study in this country, in the UK. The second was the European Roma Rights Centre, where I was asked by my old friend Anthony Lester, Lord Lester, to take over from him as chairman of that. It's based in Budapest, but it's a public interest law organisation which takes up cases on behalf of the Roma, who are the most oppressed minority in Europe. And we've had some very important court victories, most recently against the segregation of Roma children into special schools in the Czech Republic and Slovakia. I gave that up. I came to the end of my term of office in 2007. Then I was involved as a board member of the International Centre for the Legal Protection of Human Rights, Interrights, and more recently I've become chairman of something called the Equal Rights Trust, which seeks really to promote equality of opportunity and anti-discrimination legislation worldwide. So those have particularly kept me busy, and I've kept up research. I'm still working on a major comparative study with colleagues from other universities in Europe on the history of labour law. So, and finally, if I can just mention perhaps the most significant of my activities in this period was my chairmanship of the Nuffield Council on Bioethics, which took about an average 1 day a week. That council is an independent body funded by the Nuffield Foundation, the Wellcome Trust and Medical Research Council, which looks at bioethical issues. And while chairman, I've myself chaired 2 working parties, one on the subject of the ethics of research into genetics and human behaviour, like the connection between your genes and your intelligence or your sexuality and so on. And that was a a report on a subject which hadn't been looked at before. And then more recently I chaired the working party on the forensic use of bioinformation, in particular DNA. And that was very interesting. We got a report out rather quickly, and it's had a lot of coverage because it deals with all the current disputes about civil liberties, police powers on the one hand, and the benefits of DNA in fighting crime.
Fascinating. How did you come to be involved in these areas?
I think Nuffield Council I became involved in because of ignorance. I think the qualification for the job was not to know anything. The subject, like the famous Cambridge advertisement for a lecturer in what was then called Mohammedan law in the 1960s, and the advertisement said, "No knowledge of the subject is required." What they had in mind was that they were going to train somebody into the field, and I learnt on the job. I was chosen because I had, I think, it was perceived I had qualities of chairmanship, and I had a general interest in the field, partly through my work in the law of tort and on human rights. So this came in useful, and I developed my knowledge over a period. Just as I sort of reached the period of thinking I'm beginning to understand this, my term of office ended at the end of 2007. But I still do odd bits of work for the council.
And in the meantime, in 2003, you became a Fellow of the British Academy.
Yes.
And in 2004, you were knighted. How did this honour transpire?
Well, there was a leaked minute which got into the press that the committee which considers honours had said there are too many knighthoods in the law faculty at Cambridge. I think I was the 6th or 7th such knighthood. It was a complete surprise. I had no idea it was going on. I have no idea what processes come into play in it, and the citation was simply for services to legal studies. So, it was a great honour to be given this, but I took it in part as an honour to the faculty because we have this tradition. I fear I may be, and James Crawford, the chairman, said he thought I would be the last because there'd been this publicity that there were too many Cambridge Knights, but the long lines, John Baker, Sally Lauterbach, and going all the way back.
Yes. Sir Derek Bowert.
Yes.
Is also one of
that's right.
That's right. Yes. Well, that takes us then to your current work as a judge of the United Nations Administrative Tribunal. This was an appointment in 2006.
Yes, that again was a total mystery to me because I was asked by the Foreign Office whether I would like to accept the nomination, but I heard nothing further. And then one day I was in Geneva for another purpose, and a French judge came up to me and congratulated me on the fact that the General Assembly of the UN had elected me as a judge of this tribunal. It is in fact a kind of employment tribunal for all the 100,000 or more employees of the UN all over the world. It's the final kind of court of appeal because the UN, being a sovereign body, is not subject to any national jurisdiction. People who are sacked by the UN can't go to an American or British court. So this is their only legal recourse. And I've only, in fact, been doing it for a year now. And it's quite interesting. It only involves 2 months a year, one month in Geneva and 1 month in New York. And it's the whole thing's being reformed at the moment. I'm not sure how much longer I will be a member. If there's a new system, I may fall by the wayside.
So, for example, when your term comes to an end, they won't necessarily appoint someone from the UK?
No, it's not a UK appointment. There are 7 judges, each from a different region of the world, and my predecessor was an Irish judge. They're all people who have to have had senior, usually judicial experience. And so they're a very interesting group of people, drawn from different regions and different legal systems. And I've got the kind of common law slot. There's also always an American judge. And I would be replaced, when I leave, I would be replaced, I think, by a common lawyer, but not necessarily an English one.
I notice the jurisdictions include Greece, Sri Lanka, Argentina, France, Singapore?
That's currently. I mean,
Currently.
it changes from time to time. Yes.
On your visits to the United Nations, did you have any contact with the South African delegations at all?
Not directly, no. I mean, I have contact with the United Kingdom delegation, because I mean that seems to be my origin. I'm now British, not South African.
No.
Yes.
Professor Hepple, I noticed that you played a substantial role in drafting certain important government bills between 1975 and 2003. I'm thinking now of bills for New Labour and also under the Wilson government. What springs to mind there is, for example, the 1975 Sex Discrimination Bill. Was also the 76 Race Relations, the Equality Bill more recently. How did you find this experience of collaborating
I mean,
with government?
I must say I didn't actually have a direct hand in the drafting of any of the 1970s legislation, other than the discrimination legislation. I had been involved in the race relations field since I read the first book on the subject in 1968, and I was involved in what became the Race Relations Act of 1976 and the Sex Discrimination Act. I was quite closely involved with that. And then more recently I've been involved with the proposals for a single Equality Act based on our Cambridge research. But I must say I haven't really been involved in the drafting process at the government level with any of this legislation. I've been more an outside commentator making contributions. In the South African context, in Namibia, I did draft large parts of the legislation. I also drafted legislation for Hong Kong, and just before the Chinese takeover and the Chinese repealed what I'd done with trade union legislation.
So, looking back over your very eventful career, what would you say are your most outstanding memories or achievements?
Well, I won't talk about achievements, that's for others to judge, but I think I've been extraordinarily lucky. Whenever things seem to be going badly, then one door closes, another one always opens. And I've had some very stimulating experiences. I suppose above all, I've enjoyed teaching. I like the contact with students, but I have a kind of reputation as being a hard teacher who expects perfection from his students. There are others who are much gentler and perhaps get more out of their students in one way, but my approach has been to be quite demanding, but I've enjoyed it. Secondly, I think that period with up to 16 or 20 research students in Cambridge in the 70s working with Paula Higgins was extremely stimulating, and we were kind of laying down the foundations for a new subject with all the changes that were going on. So I enjoyed that. I enjoyed the creative side. One Lord of Appeal, who shall be nameless, described me as a sensible radical, and I really like that description. I hope I live up to it, because I like to do radical things, but I like to do them in a rational way. So I was lucky in having as influences, on the one hand, Sir Otto Kahn-Freund, with whom I worked on various things, who was a radical but a very clear thinker on a comparative basis. And on the other hand, I worked with Glanville Williams, who was the most rational, utilitarian man I've ever met. Very shy man, but on the other hand, somebody who would subject everything to careful analysis on a rational basis. And I think those were both influences which I've tried to bring in to bear in my work. So I enjoyed all of that, and finally I think I've enjoyed very much the comparative legal scholarship. I mean, one of my failings is an inability to speak many languages, and it's partly due to my South African background. And the result, however, has been that English is becoming more frequently used, and I can get past in one or two other languages at the reading level. So the result is that I've gradually developed contacts, and we've done a lot of comparative work together. And I think working with these colleagues, working for the expert committees of the European Commission, and also working as an expert for the International Labour Organization, the International Institute of Labour Studies, travelling for them. I was sent, for example, to Russia to advise the new government there in 1992. They've all been very real highlights in my career. And I suppose I should say that the most emotional thing was going back to South Africa in 1990 and then seeing the new South Africa and having a little role in the new South Africa.
For 27 years.
Yes.
Professor Hepple, do you have any regrets of things that you think you would like to do?
Well, we've had many regrets, but I think academically, as I've said, I'm sorry I gave up administrative law. And I think that would have been a very interesting, I suppose I would have had to give up something else, but one always has to teach a range of subjects, and you're not always interested in all of them. I think I was interested in everything I taught, but I couldn't keep them all up to the same level. But in the fields of labour law and discrimination law, I suppose I've had the greatest passion, and therefore it's been the greatest commitment. But again, the law of torts, I sort of faded out of that in the mid-90s, and a new edition of my casebook's just coming out with others doing it, and looking through the proofs, I think, I wish I'd been able to write on that, It's very interesting.
Yes. So what do you still hope for?
Well, I hope to keep up as I am, that's all I can say. And it's a wonderful environment, Cambridge, and I wouldn't want to be anywhere else, because the faculty is very kind to its retired professors, and we have full use of the facilities, and you feel part of the family. And the same applies to my college, of course. So I think it's a great environment. It's intellectually stimulating, and lots of friends in Cambridge and so on.
Well, thank you so much for yet another fascinating interview.
Oh, my pleasure.